everybody. So per request, I'm going to try to do a lecture on video for you and see where we get. We're on chapter 4 this week. I just want to give you a reminder, your outlines are due on October 3rd, so that's next week, Friday, for your research project. If you want to run something by me, please do that. These don't need to be detailed outlines, but I just want you to start thinking about what you're going to include in those projects. So make sure you get on that here so you're not rushing at the last minute, though I know some of you like to do that. Okay, so this week, chapter 4, we're looking at evidence and the distinction between direct and circumstantial evidence. So evidence, as we've kind of hit on as we've started this year, is evidence is ways to disprove or prove something. So we're going to, evidence is used in court, obviously, so you're proving it to a judge or a jury. And it can go either way. The defense could show, let's say the prosecution says the defendant committed a robbery, and the defense can show that he was actually at an ATM machine 12 blocks away. So the receipt from the ATM machine or the video from the ATM machine, that would be evidence to disprove that fact. Okay, and the beginning of this chapter, they talk about some topics that are, constitutional and also burden. So we've got the reasonable doubt that's talked about in the chapter. And reasonable doubt is what the judge or the jury, depending on if the defendant chose a jury trial, must conclude to prove that someone is guilty of what they've been charged with. The actual definition of reasonable doubt is still litigated in the courts of appeal in the Supreme Court today. But there are jury instructions in California and federally that tend to look at whether it's a little bit more than more likely than not, but it's not, it doesn't have to be 100%. Is it reasonable that you believe 12 people together on the jury that this person committed the crime? There's two types of burden that a prosecution must use and meet in order to convict someone of a crime. They have the burden of production and the burden of persuasion. So the burden of production is you're proving a fact by producing the evidence. So you can't just say something is the way it is as a prosecutor. You have to bring together evidence to prove it. So if in our Robert example, if you say he did it, you need to show actual things that he did it. Video of him there, eyewitness statements, the weapon he used, fingerprints on something. Maybe he stole money and he spent it somewhere else, and you've got the video of him spending it. Things like that would be used as a burden of production. The burden of persuasion is proving to the jury that all of those evidence that you brought together is proof as a combination that the person committed the crime. Okay, so we have two types of evidence, right? We have direct, and that proves a fact without any inferences. So if I'm there and Johnny is accused of committing the robbery, I can say, I saw Johnny do it. He didn't have a mask on. I recognize his face because we go to church together. It was Johnny. That is direct evidence. So the difference between circumstantial is that you have to have, it's not actually at there. So it comes from an inference to prove a fact. So let's say you see a guy run out of a store. He has a gun. And then you go into the store and you find someone shot. You can infer that the guy ran out with a gun, shot the guy in the store. And so that's circumstantial evidence that the person was shot. The difference between the first scenario and the second scenario is If I would have been standing in the store and saw the shooting, then that would be direct evidence. But because I only saw him run out with the gun, then it's just circumstantial. So you've got to take many different items of circumstantial to convict somebody to meet that burden. A word that I've used a couple of times and that's used over and over in the book is an inference. And an inference is a conclusion that the judge or jury can make based on the evidence. So if I say, I saw John run out of the store and he had a gun in his hand, and then I saw the clerk inside the store with a bullet in him, or bleeding, then the inference the jury can make is that John shot the person and then ran out of the store. Okay. So these direct and circumstantial evidence is used to prove everything. Okay, so we look at, if you're looking at one of the things we look at about a criminal, charged criminal, did they do it or not, we're looking at what their mindset is, and the mindset is called intent. And so it's very difficult to prove intent by direct evidence. If you don't have the person saying, I shot the person because I hate them and I went there to do it, that's about the only direct evidence you're going to have of it. So you have to look at circumstantial evidence to prove intent. So if someone walks up to someone else with a gun and they point it at them and they say, give me all your money, and they shun the gun in the face, and then the person doesn't hand over the money, so they shoot them, the prosecution can then argue that it was always that person's intent to shoot that person because they went there with a gun, they made demands, and they shot them. And then though all that circumstances together can be an inference of circumstantial evidence to prove intent. So when you think about direct evidence, why is it so hard to get direct evidence? Well, most of the time it's because defendants are the only ones that have access to it. You know, they do not have to speak and incriminate themselves, right? We learned that at the beginning. And so if you're talking about the person's mind state, they're the only ones that can tell you that. It's also a problem, like if you look at financial crimes and documentation that support financial crimes, that is information that defendants tend to only have themselves. So it makes it difficult. And if you look on page 82 and 83, there's a big description on how this is a problem with tax evasion cases. Okay, so when you're using only circumstantial evidence, you're going to be you use it to show the means, the opportunity, and the motive the defendant had to commit the crime. So you use circumstantial evidence as law enforcement to prove these three things before you present the case to the defense, or the prosecution, so they can charge the case. So what's means? Does a person have the ability to commit the crime? So like in the shooting circumstances, do they own a gun? Did someone see them with a gun? Were they found with a gun when they were picked up? Those are all ways to prove means. When you look at opportunity, the second thing that law enforcement needs to think about when collecting evidence, you want to look at, was that person able to commit the crime? Were they in the area where the crime took place? You might look at cell phone records, or look for videos, or maybe their Facebook page or other social media, and them saying where they were that day. And then the final thing is the motive. Why did the person do it? Was it maybe because they were owed money, or they're jealous, or they're hungry? That's why they went in the store and stole the food. So those are the three things you're going to, as law enforcement, try to tie in with circumstantial evidence to build the case so that the prosecution could go forward. Then the book talks about modus operandi, and modus operandi, which we call MO, is how a person commits a crime, like their pattern. So if somebody commits a lot of, let's say, rapes, and they always crawl in the window at 2 in the morning and they tie the woman up, then that's their MO. And you can, if you have several cases where they've done this, you can tie it together and bring it in evidence at the court that they have a pattern of doing something some way, and this proves that in this case it was them that did it. And in those kind of cases, you're going to look for something maybe very specific. Maybe they always use I don't know, a red rope to tie up their victim. So you're going to want to bring in all those key details to the prosecution so they have everything available to them to go forward. So then the book talks about fingerprints versus shoe prints, and are these direct or circumstantial? Well, these are circumstantial, okay, because it implies someone was there, but like with fingerprints, they could be transferred. We saw that, I think it was in, was that Bailey or Leanne's video last week? I think it was, or maybe it was Marlene. I don't know. One of them had a video where they transferred the fingerprints, Marlene. And at that point, you could actually take them and put them somewhere else. So it gives an inference that a person was there, but it's not directly showing that the person was there. Same with shoe prints. You know, there's a million people that could have bought the same Nikes. So if your defendant has the Nikes, you can use it to imply they were there, but you need other pieces of evidence to also contribute to that element of the crime. Okay, so sufficiency of evidence, that's often used by defendants to give reasons why they should have their conviction overturned. And that's where a judge will, or the Court of Appeals will decide, was the evidence that was used against them competent evidence, and did it imply and bring about enough evidence so that the jury or the judge could convict the person on that. Now, prosecution doesn't have the right to appeal on that sufficiency of evidence like a defendant does. When the prosecution loses, that's it. They can't keep going after the defendant. But the defendant can say there wasn't sufficient evidence and appeal their conviction. Presumption of innocence is also talked about in the book, and I have posted a video related to that. And then there's some more about inferences. And in inferences, there's a phrase, it's on the last page of the chapter before the key terms. I think that's page 104, but I could be wrong. There's a term called res ipsa loquitur. And that means, it's a Latin term, it means the thing speaks for itself. And so, let's say you have a murder and you have photos of the victim. And in the photos, you see the person has a black eye, they're bruised, they have bruises all over their body. And so the prosecution's using it to show, look, he was beat up before he died. And with the term res ipsa loquitur, you take the inference. The black eye, the bruises, shows, it speaks for itself. He was beat up. And so by presenting that evidence, the jury or the judge can make the inference that the person was beat up. Okay, so that's where we are for this chapter. I posted a few videos. There's a discussion this week. It requires you to do a little bit of research, but it shouldn't be that hard. And if you need some points in the right direction for that, let me know, and I can give you a couple of cases that that goes to. If you want to look on YouTube, there's some YouTube videos about different bad act cases. Okay, I miss you all. Bye.